This training video continues from Copyright Protection of Software Part 1. The following slides address further rights restrictions associated with the digital preservation of software and provide some solutions through license contract terms. The Computer Program Directive defines various rights that belong exclusively to the author, rights that have been implemented into the national legislation of the member states. Any action that conflicts with an exclusive right granted by copyright law will be an infringement if it is carried out without permission by the rights holder. These exclusive rights include reproduction and alteration, which will become relevant in the digital preservation process, as we have seen before. In the example case, the pharmaceutical company will need to obtain a license from the software company in order to digitally preserve the software program, because the software development company owns the exclusive right to actions such as reproduction, porting, migration, and emulation. The pharmaceutical company should obtain a license that allows these actions because they may be necessary to ensure usability of the software in the future. In any instance that digital preservation requires processes like porting, as you can see in the example on this slide, the software user must obtain the consent of the rights holder. This relates not only to the process of porting, but also applies to reproduction, migration, and emulation of the preserved software. The negotiation of license contract terms provides an opportunity for the company to obtain the range of necessary rights of use. Most license contracts that enable the software licensee to use the software for day-to-day business do not include the transfer of the rights of use necessary for porting, emulation, or migration. To secure the legal right to perform these actions, the license contract must include special clauses for digital preservation in order to avoid infringement of the exclusive rights of the rights holder. The more explicitly the rights and obligations are established in the license contract, the less likely there will be risk of infringement of rights or litigation. These license contracts often contain a time limitation, and licensees should not let the license expire without taking further action. Even if the license contract grants the necessary rights of use for the relevant processes of digital preservation, from the moment of expiration of the license contract, every specially granted preservation action performed by the former licensee will infringe the licensor's exclusive rights. The licensor must ensure that the license contract that contains the special clauses for reproduction, migration, porting, and emulation of the software has not expired when performing these actions in order to avoid litigation and damage claims. If the license contract has expired, the two parties must renegotiate terms. During the Timbus project, we have developed a Legalities Lifecycle Management tool, or the LLM tool. With this tool, we aim to assist users in identifying the particular ways their planned preservation actions could potentially infringe on the exclusive rights of software developers. The LLM tool behaves like an interactive flowchart that guides users through relevant questions to lead them to all the possible actions and steps of performing legal digital preservation. This tool provides users with the ability to avoid infringing copyright and to digitally preserve their business processes with confidence. For more detailed information about copyright protection of software and digital preservation and other legal issues that impact digital preservation, check out Legal Aspects of Digital Preservation, available through Edward Elgar Publishing, now also available as an ebook. This concludes training for copyright protection of software and digital preservation. For more training in the legalities of digital preservation, please see the other training videos on the website. Thank you for your attention during this video.